This meeting is being recorded.
Welcome everybody to the next instalment in our recordings for the Australian Dispute Resolution Research Network Roundtable, jointly organised by myself and my colleague, Professor Rachel Field. I'd like to begin by acknowledging the traditional custodians of the land where I'm situated at Bond University, the people of the Yugambeh language group. And I also acknowledge the First Nations custodians of the land where all the presenters are located and indeed where our viewers are located today. Our presenter today is Karen Bowers, and Karen has extensive experience in practice, both in legal practice and outside the law. And more recently, she has commenced as a PhD candidate at the University of Newcastle. And she's going to be presenting to us today on her very interesting research project, Is Mediation the Best Medicine? Evaluating pre-court procedures for medical negligence cases in Australia. So Karen, I'm very pleased to hand over to you.
Thank you so much, Jonathan, and thank you for inviting me to present today. I'd also like to extend my acknowledgement to the traditional custodians of the land for the area that I am in and for other people who are watching this video as well. So my name is Karen Bowers and I'm a solicitor in New South Wales practicing in medical negligence law. Through my work managing claims for New South Wales Health, I've witnessed firsthand the impact that medical negligence cases have on patients and their families and the health practitioners involved in a dispute. And this is one of the reasons why I've chosen this topic for my PhD. In this area of law, we have seen a push towards alternative dispute resolution options, such as mediation, as an effective way to overcome some of the perceived shortcomings of the litigation process. So there's evidence to show that mediation or alternative dispute resolution can help with things like reducing legal costs, improving timeframe for outcomes, providing a more constructive experience for the parties to a dispute, and improving access to justice and reducing the burden on the courts. So Australian Institute of Health and Welfare data estimates that more than 90% of medical negligence cases settle through mediation. But could this happen earlier than it does? And if so, what would be the outcome for the parties involved in the dispute? So the research problem I'm investigating is the use of pre-court procedures for medical negligence cases in Australia. And just to provide a quick definition for pre-court procedures, they're sometimes referred to as pre-action protocols. And it's a series of procedural requirements that are a prerequisite to commencing litigation. And they're generally encouraged, they're generally aimed at encouraging early settlement. So the current approach to managing medical negligence cases in Australia varies across the state and territory jurisdictions. And despite extensive law reform in the early 2000s, the system is still acknowledged to be far from optimal. There's information asymmetry in the system. Defendant insurers are generally very experienced players and they have access to claims data that the general public do not. And there's been limited analysis on the various regulatory approaches. And so law reform has relied quite heavily on anecdotal evidence rather than empirical research. So my PhD proposal is to examine the impact of all of these dynamics and the various state and territory laws that regulate medical negligence cases in Australia. And I'm doing this over a period of 25 years. So as you can see from my slide, I've got two main research questions and I've got two linking methodologies. And the first research question is, how has law reform in Australia impacted the number and dollar value of medical negligence claims across time and across jurisdictions? And for this question, I'm going to be looking at specific features of the laws in each state or territory, and particularly looking at the impact of whether or not there are pre-court procedures in place. And I'm going to be using a quantitative methodology to answer this question. My second question is, what factors impact or influence the decision to mediate medical negligence cases in Australia? And for this, I'll be focusing on some of the perceived barriers to early mediation. And again, I'm specifically interested in looking at the use of pre-court procedures in Queensland, where they're very common, versus New South Wales, well, not very common where they're in place, versus New South Wales, where we don't actually have anything in place. So I would like to have a look at the comparison between those two jurisdictions. And I'm looking at a qualitative methodology for that. So I'll now move on to talk a little bit more about my proposed methodologies. As I said, it's a mixed methodology. And for my quantitative, I'm actually going to use the process of legal epidemiology, which is the scientific study and deployment of law. Now, this is quite a new methodology, and it's mostly been used in the United States. It hasn't been used, as far as I'm aware, that often in Australia. And certainly it hasn't been used for this type of problem before. But it's actually very applicable for the research problem that I'm investigating, and I'll go on to explain why that is in a minute. For the qualitative methodology, as I said, I'm looking at face-to-face semi-structured interviews and or focus groups with solicitors and barristers in New South Wales and Queensland. And this is really going to be the second part of the research, and it will be a chance to then drill down with these experts in this area of law based on some of the things that come out of the quantitative research. That's how we're hoping to link the two methodologies. So as I mentioned, the legal epidemiology is sometimes considered like a natural or observational experiment, and it works really well in situations like the medical negligence area, where you've got differences between various jurisdictions within a country. So in the early 2000s in Australia, we had the rising cost of professional indemnity and public liability insurance. And this was known as the indemnity crisis. And the insurance industry came out very strongly and said, oh, there's been an explosion in litigation. There's large payouts. We're having a crisis. So in May 2002, a decision was made by the federal government to appoint a panel to review the law of negligence. And this was known as the IP review because the panel was chaired by Justice IP. And in September that same year, a report was released, the IP report, which had 61 recommendations for law reform. And one of the first recommendations from the IP report was that we needed to implement the laws consistently across Australia. But instead, this didn't happen, and we ended up with this patchwork of laws, and some reforms were implemented in some states and territories, and it was really up to the individual state and territory what they did. So this actually works really well for this methodology. It's an advantage because we now have a way where we can compare what's happened between the different states and territories. So I'm undertaking legal mapping, and that means we'll be capturing the features of law and identifying how they've changed over that 25-year period and how they've changed and how they're different between the various jurisdictions. And so there's two main methods. There's the legal assessment, which is at a point in time, or there's policy surveillance, which is that longitudinal over time. And so I'm undertaking policy surveillance. And just to give you some idea with pre-court procedures or pre-action protocols, we've seen various forms in Queensland, South Australia, ACT, and the Northern Territory at various points in time. Northern Territory has repealed the legislation. There's also been discovery pre-action requirements in Tasmania under the Magistrate Court rules. So we've got some differences there as well, compared to a state like New South Wales, where I am, where we really haven't seen any substantive law reform around pre-court procedures other than the Commonwealth genuine steps requirement. So this slide just illustrates how policy surveillance fits in with the law and policy environment. And I think we all know that lawmaking is an intervention that has measurable effects, but it often unfolds without evaluation or monitoring. And so we sometimes end up with quite anecdotal evidence for law reform rather than more empirical evidence. And this is something that I'm hoping that I can try and contribute some empirical data as an outcome of my PhD. One of the benefits of the policy surveillance process is that we can turn law into data and we can track changes over time, so we can assess the impact and effectiveness of laws. We can provide an empirical basis, as I said, particularly for laws that are shown to promote public health. We can provide support for qualitative evaluations. And so that's why I've got this mixed methodology where we're hoping to get the quantitative data first and then use that when we do the qualitative discussions to then maybe drill down into some of the reasons why things have come out in the quantitative data. And it's also to guide policymakers for future legal interventions. So this slide just illustrates some of the project considerations for a policy surveillance project. And on the left-hand side, I've got the criteria to consider. And then on the right-hand side, just shows my project, particular project. So do the laws vary by jurisdiction? Yes, we have these state and territory variations in laws. Are the laws measurable in written form? Yes, we're very lucky in this country that every state and territory has their written law published by their government websites. Are secondary sources available that you can compare with your data set? So there is APRA claims data and Australian Institute of Health and Welfare data available. I'm actually going to compare my data set to the APRA claims data. And the reason being is that covers the whole 25-year period, whereas the Australian Institute of Health and Welfare data is actually only captured post it. So I'm actually hoping that with the APRA data, which is publicly available, it is self-reported by insurers, but it's self-reported under statutory requirements. So there is a certain level of compliance, and it will cover the entire 25-year period. Has topic not been extensively studied? I think the impact of civil liability reforms has been studied quite significantly post-it, but there are not many studies that have covered, again, that 25 years pre and post-it. And does the topic affect public health? I think the research is applicable to really diverse things such as improvements in clinical practice, the areas around costs for the healthcare system, for instance, from rising premiums or defensive medicine. So this is the policy surveillance process that I'm following. And this method was pioneered at Temple University in Philadelphia. And you can refer to the lawatlas.org website for other publicly available data sets and also the online training modules. I was lucky enough to attend a 3-day seminar last year virtually, where I actually got to run through a policy surveillance project for COVID mapping and data in the United States, which was really interesting and a really good experience to understand exactly how the model works. It has 8 steps and it's an iterative process. So you need to be constantly refining the model and refining your data and recoding as you go. Step 1 is to develop a research question to be tested empirically. And I'm using the null hypothesis, which is that pre-court procedures have 0 effect on the number and dollar value of medical negligence claims in Australia. Step 2 is to identify the laws and legal mechanism, which means you're looking at whether or not the law is present or absent in a jurisdiction, but also looking at the different features of the law across jurisdictions. Step 3 is developing the coding questions, and I have 25 coding questions that are based on different features of the law. And the questions have to be objective, so they can't be open to interpretation. So you need to use like a Q&A format, so either yes, no, or select all fields that apply. And it's really important that we're measuring the law through observation of the underlying text of the law rather than interpreting what we think the law means. And then you have to also design questions that will mirror the outcome data that you're then going to compare your data set to. So steps 4 to 6 are creating the legal data, and that involves collecting the law, so recording the citation, effective date, statutory history, and the body of the law. For policy surveillance projects, we're coding over the entire time period. And so we're using a lot of dummy variables to just hold the space for where there is no change or no amendment in the law. And then every time the law has been amended, then we recode there and then use dummy variables again to hold the space until we get to the next change in the law. And then finally, the next step, which I'm up to but haven't started yet, is to merge the legal data that I've created with the outcome data, and then to map trends and correlations. So that legal data is the data set I've created, which has the state and territory laws over a 25-year period, coded down in a way that's objective and replicable. And then I compare that to the publicly available APRA outcome data set. And that has things like the number of claims per year, the dollar value of claims, the payments made on claims, etc., specifically for medical negligence. And I'll be then doing descriptive statistics, so things like mean, median, mode, variance, standard deviation. I'm also hoping to do some bivariate explanatory analysis and then follow that by some multiple variate analysis. And then we'll also test some hypotheses about the relationships and then do comparisons between the different jurisdictions. So hopefully in the next year or so, I'll be able to come back and report on some of those outcomes once I've done that future analysis. So as you can see from the policy surveillance process, quality control is at the center of the model, and it's really important throughout the whole process. And one of the ways that we establish the quality control is we actually establish a research protocol, which outlines the whole methodology and process. And with it being iterative, if any changes are made, we have to revisit and recode. We're also looking at things like redundant legal research and coding, and then calculating the rate of redundancy between researchers and aiming to get that rate of redundancy down to less than 5%. I'm also doing post-production statistical quality control. So we're doing a random sample, again, selected for redundant coding, and again, trying to get that rate of redundancy down to 5%. So recoding until we get that rate down. And the main reason for this is because the data set that I've developed will become publicly available as part of my research. With this quality control research protocol, it means someone can pick it up and they can go ahead and use it for their own research. And it's, I guess it's for transparency and so they can replicate it. So finally, I just wanted to talk a little bit about some of the limitations in the methodology. And this is an area that I would be really interested in feedback on. If anyone has got any suggestions, that would be absolutely fantastic. I'm really looking at this early stage of my PhD for all of the help and good ideas that I can get. The legal epidemiology methodology, it does only capture law on the books. So it doesn't look at implementation or enforcement. And so, for instance, the influence of court decisions on the law is not going to be captured in that model. And I guess this is why the qualitative side of the research is so important, because that will be able to tease out some of the things that we won't be able to capture with the quantitative data. There's also the issue that US data sets generally have 52 states, whereas we only have 8 here. So that's one of the reasons why the time domain of 25 years is going to be necessary to overcome this, so that we actually have a large enough data set to get some meaningful statistics. So we'll have 8 states, we'll have 25 questions, and then over a period of 25 years. So that gives you an idea of what the data set's going to look like. There's issues around cleaning the outcome data that we're using, making sure that the APRA data has been cleaned. I've got quality control for the data set I'm creating, but how will I look at the outcome data? The issue of something that's always going to happen with this is the admitted variable bias. And so, for instance, are there things that we're not even looking at? Like, were there more lawyers over the time period? Was there changes in the restriction on advertising for personal injury lawyers? And are these things that we could capture in a meaningful way in our data set so that we're not just looking at the law on the books, we're actually looking at what factors were outside of that that also potentially impacted the number of claims or the dollar value of claims. The time lag between when an event occurs or when a claim's notified and then when a statement of claim is being filed, particularly for like long tail obstetrics claims, that could be up to 25 years or under 20 years. Also the issue of COVID-19 on outcome data. We know that there's been a huge drop off in the number of claims in the 2 COVID years. And so we may need to actually exclude that data. So we're hoping that some of these limitations we can overcome with the qualitative data collection. But as I said, again, we'd be really interested in any other suggestions. The other thing that we're really interested in is we will be wanting to talk to lawyers in Queensland within the next 12-month period. So if anyone is working in the area of medical negligence law as either a solicitor or a barrister and would be interested in taking part in one of our focus groups, please get in touch. I would absolutely love to hear from you. And that's something that we're looking to do towards the end of this year or early next year. And we're really interested in getting that comparison between how things are working in Queensland versus New South Wales, given that PIPA seems to be pushing people towards earlier exchange of information, earlier mediations or informal settlement conferences. And is that actually meaning that matters are going to be resolved earlier and potentially in a way that both parties see as beneficial? We'd be really interested to hear people's views on that. And so that brings me to the end of my presentation. And thank you so much for taking the time to listen to me.
Thank you so much, Karen. I'm just trying to reformat the screen so that we can all see each other.
Yeah, I'll try and take off my share screen. Yeah, try and figure out how to do that.
So, Karen, I thought that was extremely interesting. This is a methodology that I'm not familiar with from research I've encountered in the past. And I'm sure that the people here in the room might have some questions and comments on that. I just had one question to start with, which is about the quantitative aspect to your study. So it seems like what you're doing with this approach of legal epidemiology and policy surveillance is basically trying to map in a rigorous way the correlations between the black letter law on the books and other observable phenomena. But I was wondering how that methodology enables you to map any causal links between those phenomena, or is that where the qualitative aspect comes in?
I think you're probably never going to be able to make a causal link because I think of the limitations of the methodology. But I think what we'll be looking at is correlations. And I think the whole point of the qualitative, or what we hope to get from the qualitative, is if we have correlations that we think are interesting or that we're not sure we can explain, we can then use the qualitative to maybe find out how things are occurring, I guess, in practice. So I think the whole thing about how law occurs on the books can sometimes be very far removed from how people are actually implementing it in practice. So I think if you just went with the quantitative, you might say, oh, well, it looks like, for instance, expressions of regret and apology, it's protected by law. Oh, people must be doing it now. And then you go and see studies where they say, well, actually, no, doctors aren't doing expressions of regret or apology because they're not confident that it's protected, or they don't understand what that means just because it's protected by the law now. Does that actually mean they can do it? So it's really looking at, from the qualitative, how that black letter law is actually being used at the coalface, I guess, is the way of understanding.
And so what do we learn from mapping the correlations?
Sorry, I might just need you to repeat that. I just missed that, sorry.
Yes, sorry, what do we learn from mapping the correlations?
So I'm so sorry, I just missed that again. I wasn't quite sure.
Yes, so what do we learn from mapping the correlations?
Oh, what do we learn from mapping? Sorry, yes. So from mapping the correlations, hopefully what you learn is well, first of all, you might find that it's completely random. So you might actually go through this entire process and find actually we can't map any correlations at all and it's completely random. And I guess what you learn from that is that do we even know the impact of the law reforms that we're putting in place? But hopefully we will find things that are correlated. And so one of the things that I would be very interested in is if you look at the outcome data now, you've got states like South Australia where they haven't had this same explosion in medical negligence cases that we've seen in New South Wales. And what is the reasoning behind that? Is it because they've got some pre-court procedures in place, people are meeting earlier, people are settling earlier, or is it something completely different? As I said, is it something to do with the number of solicitors, or is it to do with, I'm not sure. But I think if we can map some correlations, what we're going to at least have a look at is see, are there any patterns that we can look at between the states that are doing these things versus states that aren't doing these things?
I might hand over now to Rachel and Lawrence if they have any comments or questions for Karen.
You go ahead, Rachel.
Okay, so thanks, Lawrence. Thanks so much, Karen. That was really interesting. It's going to be such a valuable contribution to the Australian literature. I've been familiar with the anecdotal side of the evidence around medical negligence in the DR space for ages. There was a judge of the Court of Appeal here in Brisbane whose brother did a lot of medical negligence mediations in Sydney, and he had some horrendous stories of how those processes happened and how, people were put in separate rooms, but their heads were banged together nevertheless. And, so I think that you mentioned that we've been going with law reform on the basis of anecdotal evidence, and we need proper evidence. And one of our network members, Alison Boyle, who's done a PhD recently, also through University of Newcastle, has said that we need that evidence to know how effective mediation is. So you're really going to make a great contribution, which is wonderful. And I think that the mixed methodology as well is so thorough. The way that you talk through that, it's just so thoughtfully designed, and we'll give some really strong results. I just wanted to dig a bit into your motivation for this. What do you want to achieve out of this work?
So I think being in New South Wales and having done a lot of mediations, I think I have noticed that sometimes the best practice of a facilitative mediation sometimes gets lost along the way. And I think sometimes it does become people in separate rooms trading numbers. And, do the participants feel that satisfaction at the end if they haven't necessarily had an apology from the hospital or the healthcare professional? Do they feel that they've got closure? I'd like to see possibly a more facilitative style of mediation being employed, or to see if people find it effective. I know Dr. Tina Popper did some really interesting work in Victoria, which I've looked a lot at her work. And that was one of the big things that came out, was people said, could we use mediation more effectively in this area? Are we sort of selling ourselves a bit short with the way we're using the process? And I think that's something that will come out of the qualitative interviews. It'll be really interesting, I think, to see the different views of practitioners in Queensland versus New South Wales, because I think the system is operating quite differently across those two states. That's my anecdotal feeling, whether or not
that's your hypothesis. So you're going to see whether it turns out. I just put the link to Tina's work into the chat in case any of the viewers want to access that thesis, because I think it's probably the most recent thing just before your
Absolutely.
work.
And definitely when I first started the PhD, my first thought was I wanted to do basically replicate pretty much what she'd done, but do it in New South Wales. And it wasn't until I started the thesis and then I went down this whole quantitative path. And as I said, it hasn't really been done with this type of problem at all. But when I spoke to the people in the States, they were very keen to see it done in this area. A lot of the, it's been used a lot for public health issues. So for instance, seatbelt laws or distracted driving laws or things like that. But I think because we have had such a different implementation across states and territories, it is quite applicable to this particular area of law here in Australia. So it'll be interesting to see. I mean, as I said, I'm not promising anything, but it'll be interesting to see what the results come out with.
Thank you. Yeah. Over to you, Lawrence.
Thanks, Karen. It was terrific, and especially on the methodology, which is also new to me, and seems to have a lot of potential. I mean, there are many moving parts, but yeah, it sounds a refreshing kind of approach. Yeah, some of the things you've sort of touched on a bit already. I suppose I'm still not entirely clear in my mind. In an earlier slide, you said that you were referring to the written laws, and I was kind of, you know, that we do have in our jurisdictions the written laws, access to them, and so on. And I was wondering whether, you know, there's any scope. And I appreciate that whenever people suggest things, you're probably thinking, I've got enough to do already. But there's a lot of soft law in the compensation area, because I work in the work injury area, and I'm just astonished how much it turns on accidental and other things. And then towards the end, you say, and you're not looking at the court decisions. So I just wonder if you could, I'm sure I missed the link here, but what exactly will you be looking at then in terms of the law?
Yes, so it will literally only be law that is transcribed in legislation. And I did go down the path of looking, could you somehow incorporate court decisions? Because Professor Wright from Newcastle University did a lot of work post-it where he actually looked at the number of court decisions and actually said, I'm not sure that there was such an explosion in litigation as was claimed pre and post, the pre and post it, like, was it really a indemnity crisis? And I think that research needs to be done, and I think it's really important research, but it's very, very hard to do because it's very time consuming, and you have to actually almost, I think it's possible to get Supreme Court cases, but it's quite hard to get, you know, everything that's filed, and most things end up settling. So you might not even get published judgments. You're only getting a really small percentage of what actually comes out. So I did look at, could I somehow incorporate judgments into my data set in an objective way that wasn't subject to interpretation, but I haven't actually come up with any answers for that yet. So at the moment, my data set that I'm creating that I'll compare to the outcome publicly available data is literally only going to be law that is transcribed in legislation in various forms of legislative instruments.
Yeah.
Well, thank you so much, Karen. If there are no further comments or questions, we might wrap up now in the interest of time. I'd just like to thank you again for participating in our roundtable this year. We're always delighted in the ADR Research Network to have new participants to join our circle, and we hope to see you back in the roundtable in future years to report on the outcomes of your research. So thank you very much.
Thank you for having me.
Thanks, Karen.
Okay.
Thanks,
Bye.
Karen.